Welcome to today's talk on Texas divorce processes explained with a particular focus on collaborative law. If you'll bear with me a minute, I will start sharing my screen and start the presentation. Okay, here we are. So, first of all, the talk outline. I'm going to tell you a little bit about me, why you're hearing about Texas law from someone with my accent. We'll do an overview of uncontested divorce, traditional divorce, look at mediation. We'll do a deeper dive into collaborative law. I'll provide you with some resources, and then I'll direct you to where you can ask questions afterwards if you have any. So, yes, I am a Brit by birth, also a US citizen, but I was born and brought up in London. I met my husband, a Texan, many moons ago, and we have two teenagers. We've been living in Tarrant County for the past 16 years. I was a stay-at-home mum for 8 of those years. Way back in the midst of time, before then, I did my undergraduate at Cambridge University in modern languages, French and German. But I actually speak 5 languages, so English as well, and Italian and Spanish. I am also dual qualified, so I qualified to practice law in England and Wales before I had children, a long time ago. And then more recently, I have qualified as a Texas attorney. Again, way back 100 years ago, I practiced transactional law, chiefly corporate finance law for some of the biggest, best law firms in the world. I focused on international capital markets, not as glamorous as it sounds. And then again, more recently, I went back to law school and did a master's in Texas at SMU, and I loved it. And that's what led me to family law. I like people. I like having people at the center of my work, and I wanted to use my legal skills to help people at what are some of the hardest times often in their adult lives, and that's often divorce and child custody issues. I do also do other areas of family law, such as adoption and international child abduction and marital agreements. So what you're all here for is talking about divorces. So I thought it would be good to think about how all divorces, legally at least, regardless of the process, start and finish. So they all start when a petition is filed at court, and they all end when the final decree of divorce is presented to the judge for signature, the judge signs it, and then it's entered. And the fastest time between those 2 points is 61 days. I haven't seen it done in 61 days, but it is legally possible. And as I've said, there can be a huge amount of variation as to what goes on and your experience, and maybe if you have children, your children's experience, your soon-to-be ex-spouse's experience of life in general, actually, before you file for divorce, what happens between, and what even happens afterwards. And I really do think that the choice of procedure can have an impact on that. So first of all, uncontested divorce. Now, this isn't what some people think when they come to me and they say, oh, we want to do an uncontested divorce. And they think that what they're saying is, oh, we both agree, we want to get divorced, and we're going to go on the no fault ground. So incompatibility, insupportability, unlike adultery or cruelty or one of the fault grounds. But that isn't what an uncontested divorce is. An uncontested divorce, legally speaking, really, is where the parties agree on everything. And so if you have property and you have children, then that means you agree on how the property is going to be split up between you, how the kids are going to be dealt with, who's going to make the major legal decisions concerning the children, where they're going to live most of the time, and who, if anyone, is going to pay child support. So as you can see, there's actually quite a lot to agree on. And if you're getting divorced, then the chances are you're probably not going to agree on everything. But if you do, that process is certainly open to you. And if you are unrepresented, then you are likely going to use some checkbox forms that you can get from the courthouse or online. Just a caveat, there can be some enforceability issues with those further down the line because enforcements are very technical. And those checkbox forms may not meet all those technicalities. If you're represented, or at least if one of you is represented, then the lawyer, or if there are two lawyers, one lawyer will draft and the other one will review, but they will agree a draft and you will sign what's called the agreed final decree of divorce, which is then presented to the judge for signature and entry. So traditional divorce, as you'll see, lots of bullet points on here. And as I've said, lots of hearings. Now, you may well have heard that most divorce cases settle. It's true, they do. I think it's around 90%. But that doesn't mean that you don't go to court a lot of times between the filing of the divorce case and that entry of the final decree. So let's see what happens in a traditional divorce case. So after the petitioner has filed the petition at court, then the respondent needs to be served with that petition and sometimes also a temporary restraining order. Now, just a little sidebar here, a TRO, as we call them, that's not a kick-out order where you're asking the judge to say that your spouse can't enter your house, the marital home, for a certain period of time. And it's not a protective order where you are asking the judge to order that your spouse not come within a certain distance of you and or your children for a certain period of time. A standard temporary restraining order is one that is essentially merely asking that respondent be ordered to behave in an above-the-board manner during the pendency of the divorce. So things like don't hide money, don't start squirreling money away, don't be selling assets without agreement with you, don't change passwords on things, don't stop you from entering the marital home or using your car, not to behave in a threatening or harassing manner to you, and if there are any children, also to the children. So that's what a TRO is. Anyway, once they've been served with that, then within 2 weeks to 4 weeks, there will be most likely a temporary orders and may possibly also a temporary restraining order hearing. Now, of course, you can agree not to have that hearing. You can agree certain orders about what's going to happen to property and children while the divorce is pending. But if not, you will have that temporary orders hearing. And a temporary orders hearing is essentially a mini trial before discovery really kicks in. And so it's on relatively little information. And so it can feel like a bit of an ambush. And particularly where children are concerned, it can be of vital importance because the judge is going to make orders as to who is going to be able to make the legal decisions, most of the legal decisions about the children during the pendency of the divorce, where the children are going to live most of the time, and child support payments. So that will set up the status quo normally for the duration of the divorce proceeding. And if that arrangement works relatively well, then the chances are that those orders relating to the children are likely to be very similar to what you're going to get at a final trial or even an agreed final decree of divorce. So that can be of critical importance, that temporary orders hearing. Once the temporary orders hearing is over, or you've got agreed temporary orders, then you move into discovery. I'm sure you've all heard of discovery. Discovery is essentially a vast information gathering exercise. So your lawyer will issue discovery requests to the other side, and then the other lawyer will do the same. Or of course, if you're representing yourselves, you can do that same thing. And when there is property and also when there are children, then you've got essentially two buckets that you're thinking about with discovery. So when it's the property side of things, you're looking at bank statements, generally going back at least 2 years, possibly quite a lot more than that. Bank statements, credit card statements, mortgage statements, mortgage deeds, potentially if there are any businesses, P&L statements, balance sheets, tax returns. those are the kinds of things that are covered in the financial side of discovery. Where children are concerned, if you and your spouse are essentially fighting over who gets to be the person who is what we call primary, so the one who gets to make most of the legal decisions about the children and probably also where the children are going to live most of the time, then you're going to be looking at things like school records, medical records, maybe mental health records, correspondence between potentially you and your spouse or you and your children. So those are emails, text messages, you could have photographs, videos, audio recordings. It can be quite voluminous, as you can see. So once those discovery requests have been issued, and then the time has been, normally the other side will have 30 days to respond. And then each lawyer is going to go through with a fine tooth comb the information they've received for two things. One, to see if there's anything missing, and two, to see if the information they've got leads them to ask further questions and to ask for more things. So as often is the case, you won't get everything that you've asked for. And so then your lawyer is likely going to have to re-request that information and possibly even go back to the court to request that the judge compel your spouse to produce that information. So that's another hearing. And then there may be other hearings that happen during the course of the divorce, depending on how you and your spouse act throughout the divorce, and also how long the divorce drags out. So you might have other temporary orders hearings along the way. You could possibly have other motions to compel if you need more discovery. You could have enforcements on temporary orders if the children aren't being dealt with according to the judge's orders. So quite a lot of hearings are possible throughout the pendency of the divorce. At some point, probably fairly close to a final trial, you will go to mediation. And we'll talk about that a little bit more in a minute, but mediation is very much part of the litigation process. If you don't settle prior to or at mediation, then you're going to go to final trial. And final trial in Texas can either be a bench trial in front of a judge, or it can be a jury trial. Either of you has the right to request a jury trial. And in Texas, it's the only state, as far as I'm aware, where the jury can actually decide some really key things about where your children are going to live, with whom. The judge will still have some key things to decide, but the jury can be very important in a family law trial in Texas. So finally, again, as we've said, the judge or the jury, could be both, will make the final decisions if you can't agree. And where the judges are concerned, which is what is most likely, it's quite rare to have a jury trial in a family law case in Texas, but it does happen. But if the judge is deciding, you're going to get a pretty cookie cutter approach. And there's good reason for that. We have the Texas Family Code, which is a voluminous, and I'm just going to show you, huge, that isn't all of it, but most of this is the Texas Family Code, a huge, huge code, which tries to cater for the millions of divorcing families or parents who are not married but are having in a custody dispute, all their issues in that one code. And so, of course, they do try to create a fairly standardized approach. So it isn't with your particular family in mind. And of course, judges are trying to follow precedent as well as case law develops. Of course, all the court filings are by and large public. So anybody that has the inclination can go online and hunt about and get on the court's filing system. And if they want to pay for it, they can get your pleadings. And some of those can contain quite personal information, especially where you filed supporting declarations or affidavits for relief that you're requesting. And then proceedings. So all hearings at the court are, again, by and large public. So your spouse's friends and family can show up to support him or her. Same for you, but also anybody else that happens to be in the courtroom on that day can sit in on your proceedings. And of course, it is necessarily designed to be an adversarial process. So I want to talk a little bit about mediation now. Mediation can happen in two ways. It can happen prior to filing. I do understand that some people go and see mediators before they ever file a case. And while that's certainly possible, it's not one that lawyers tend to be familiar with. It does tend to happen without lawyers, which you think might be a great thing. But just be really careful with that, because if you agree something in that mediation and you end up with what's called a mediated settlement agreement, that agreement, absent some really rare circumstances, is a legally binding agreement that is extremely difficult to get out of, and is what will ultimately need to be turned into your final decree of divorce that's signed and entered by the judge. So just be really, really careful about that, and strongly consider taking legal advice before you enter into that kind of mediation. In any event, the mediator, whether it is prior to the litigation process kicking off or afterwards, the mediator will not and should not provide legal advice. Either if it's prior to the filing and they're not a lawyer, then they could get themselves in hot water of the unauthorized practice of law. And if it is after the mediation, in any event, if that mediator is a lawyer, which they likely will be, they cannot, from their own ethical principles, they cannot advise to opposing parties. So they will not be providing legal advice, but that's what your attorney is there for. Mediation in Texas is, in the litigation process, almost obligatory. Every judge that I know, all the counties that I've practiced in, do require the parties to have attended mediation prior to allowing them to have a final trial. It is a confidential procedure. It is a shuttle form of mediation. So you and your spouse will be in separate rooms. Often you won't even see each other on that day. You might arrive at slightly different times. You might enter through a different door. That might sound great to you, but you're not going to see your spouse generally during that mediation. And you will sit in one room with your attorney, and he or she will sit in the other room with theirs. And the mediator is going to go back and forwards. So sometimes the mediator will be with you and sometimes with your spouse, and you'll be hanging out with your lawyer in the meantime when they're in the other room. It takes place generally over half a day or a day. Sometimes it can go for 2 days. A half a day mediation generally will only deal with one issue, such as property. But if you've got property and kids, then you're likely going to be looking at a full day of mediation at least. And if you've got more complex issues and there's businesses involved or all sorts of other complicated assets, then it could take longer than that. As I said, it's often shortly before the trial date. Now, there are several reasons for this. One is that a fair amount of discovery has to happen generally before then for your lawyer to be in a good position to be able to advise you. And also because valuations should be obtained prior to that date, so that you know the numbers that you're talking about, and they're numbers that can be backed up. They're not just numbers that you plucked out of thin air. And also because the mediators tend to be, at least in the litigation legal process, they tend to be very senior lawyers and or retired judges in your area, and they're really booked up, so it's hard to get dates with them. And then at mediation, you are going to get probably a relatively cookie cutter approach, but with a few tweaks. So it's going to be fairly cookie cutter because the mediator and your attorney are going to tell you largely what the judge in your court, because your case will have been assigned to a particular judge when it was filed, how your judge is likely to rule on certain issues. Because you haven't managed to settle prior to mediation, you're probably quite close to trial. So what you're really trying to do is come to an agreement, but knowing that you haven't been able to agree beforehand, and you are trying to save yourself the pain and the expense and the trauma of actually going to final trial. But knowing that because you haven't managed to resolve things, it's probably not going to be that different. You might get a few extra little tweaks that are particular to your case, but it's going to be fairly standardized. And then, yes, you will end up with a legally binding agreement called a mediated settlement agreement, which will set out all the essential terms of your agreement. But that is not the final decree of divorce. And that's a really important thing to know, because if you're unrepresented and if your spouse is also unrepresented, then somebody has to turn that into something that a judge is going to sign, an agreed final decree of divorce. And that takes a fair amount of work, because it takes quite a lot of fleshing out to produce that final decree of divorce to make it an enforceable agreement. And again, be very wary of anything that is not in that agreement know that it is not going to be in the final decree of divorce. So that is something to be very careful about. And I would caution people to undertake mediation without at least having spoken to a lawyer in advance, and most likely, really best, you should be represented during mediation. So collaborative divorce. This takes up an entirely different section, a nice short section of the Texas Family Code, Chapter 15, and it sets out a different process from the traditional litigation one. The parties can, in fact, choose to file a joint petition. So no one's a respondent, and there is no need for formal service. If the parties agree, your lawyer can accept service on your behalf. Of course, in the traditional litigation process, somebody can sign a waiver of divorce, a waiver of service, but that isn't as common. Again, back in the collaborative world, once the parties have agreed to follow the collaborative procedure, then the attorneys will file a notice with the court that that's what's happening. And then the court is hands off. There are no hearings set. The court lets the parties and their lawyers get on with it. And they are a series of very targeted meetings which follow a very clear roadmap of understanding people's goals and interests, gathering information, which is a much more targeted form of informal discovery, option generation once the information gathering process is over, so figuring out what all the possible options of dividing up the pie could be and how the children could be dealt with, negotiating, and then finally reaching settlement. And yes, if you reach an impasse at any point and it's looking like you're not going to be able to move forward, then yes, mediation can also be used through the collaborative process. And it's pretty much the same process as I previously described in the traditional litigation one. You might want to use a mediator who is familiar with collaborative law. So here are some key features of collaborative. It is a voluntary legal process, so both parties have to agree to follow the collaborative process. It is confidential, so all the discussions and negotiations are private and cannot be used in court, except for any documents that would otherwise be discoverable, like bank statements or things, or if you've had a business evaluation that you've agreed that can be made public and used in court if you don't manage to settle through collaborative. And it is flexible. It does try to reach a bespoke agreement that works for the parties and any children involved. So it tries to step away from that cookie cutter approach. It is a team approach. So I know you're probably thinking dollars, but bear with me. You have, each side has an attorney. You can't do it without an attorney. The statute says that parties have to be represented, and there's good reason for that. Often, especially the collaboratively trained lawyers, we do try to bring an element of reason to the process. We try to keep the temperatures down. And neutrals, we use those. So we have one financial neutral and one mental health professional, sometimes known as a communications expert. Those are generally the two key team members in addition to the lawyers that we use in Texas. And each team member does what they do best. So the lawyers advise their clients, of course, on the law, and they're there to support them in the meetings, but be prepared to do quite a lot of speaking yourself, self-advocacy, but supported by your lawyer. And then the financial neutral deals with essentially the discovery. So instead of paying two lawyers to do a massive, what can be a fishing expedition, it is much more targeted. The financial neutral meets the parties and understands the issues in their case. And then they will draw up a checklist of what information they think they need. And then they will review that information. Yes, the lawyers will look at it, of course, to do our own due diligence, but we'll take a much more high-level view because we are trusting that financial neutral to do his or her job properly. And so therefore, that is very much a cost-saving exercise. And then the mental health professionals are absolutely invaluable to the process. They run most of the meetings. They ensure, therefore, that the process stays on track, and they ensure that everybody is civil, that people are heard. So they reframe things if they feel that somebody hasn't expressed themselves in a way that somebody else can hear them properly. And also, where there are children involved, they can work offline, so without the attorneys, but just with the parties on the parenting plan for the children. They don't act as therapists to the clients in the collaborative process, but they can certainly recommend therapy when needed. And yes, sometimes we can add other team members if it seems helpful. So sometimes we'll use child specialists, business evaluators, mortgage specialists. But generally, the core team is those 4 people, the 2 attorneys, the financial advisor, and the mental health professional. So I think collaborative is generally best for parents, partly because that Texas Family Code is pretty restrictive when it comes to children's issues. It's restrictive on child support, spousal support, and certainly when it comes to possession for the children. You can see by my putting that in inverted commas, I hate the term possession because it indicates that children are actually objects rather than people, and says something about the drafters, quite frankly, and their understandings of children and family dynamics. Extracurricular activities, though a judge will often award an allocation of that payment, it isn't actually covered in the Texas Family Code, and there likely won't be the kind of detail that you may think necessary for your particular family to go into. Texas Family Code doesn't cover college fees. In fact, generally the court does not have jurisdiction after the children turn 18 and graduate from high school. So that's also something that can be explored in the collaborative process. And so I said it is designed as best possible to meet the needs of the individual parties and families. Of course, you still have to negotiate within the realms of reality, but it is a much more tailored process. It is also a much less stressful process when you are trying to continue working and raising your children through a divorce, and you're having to deal with discovery requests and going to court. That can be incredibly stressful. Collaborative tries really hard to be mindful of the family system as a whole. So again, I think it's best for children. As I said, it is designed to minimize conflict. The team altogether tries to think about the family as a whole. Even though that family is splitting, it's a split system, it's still a system. And it tries to put the children at the center without having them in the eye of the storm. As I said, you've got experts who can design parenting plans for your kids, not some judge, but a mental health professional and child specialist. Again, in the traditional divorce process, if your children are under the age of 12, then they don't get a say in the process. The judge is not going to speak to them. And if they are 12 or older, then you or your spouse can request that they speak to the judge. And that might be something that they do or don't want to do, or that you do or don't want them to do. And it can be very stressful for the children. And of course, judges are not specially trained to speak to children. Whereas if you have a child specialist, that person is another mental health professional who is qualified to work with children, and their goal is purely to understand what the children's needs are in that divorce process and to be their voice, an unbiased voice, and that can be incredibly valuable. Parents, again, can agree extracurricular expenses and college fees. As I said, that can be hugely valuable in the collaborative case. If you have a special needs child, then collaborative is absolutely, I think, the best process for determining how that child's ongoing needs are going to be met, both financial and practical. And yes, co-parenting is actually a goal of the collaborative process when you have children, unlike the traditional divorce process where it's adversarial. People tend to get increasingly polarized throughout the duration of the case. But at the end of it, they're told, oh, you got to get on and co-parent. And that can be really tough, both for the parents and the children. So I also think collaborative can be really useful if you own a business. You might just own a business, you might run a business together, one of you might run a business, but collaborative can provide a negotiation forum that really doesn't exist in the traditional process. And therefore, it does allow for some creativity and flexibility, again, within the realms of reality. And if that business is going to be evaluated in the collaborative process, we generally use a joint business evaluator. Whereas in the traditional litigation model, you're probably going to have 2 business valuations, so double the cost, but also the business evaluation is likely going to favor the person who's paying for it. It may not be the most accurate business valuation. So that can lead to further argument and further expense if you have two different ones. You may even end up with a third business evaluator in the traditional litigation model. So there are some cases that are unsuited to collaborative law. So domestic violence cases, now that is a big red flag generally, especially where there's ongoing family violence. It can be possible in some limited cases. So say there were a couple of isolated incidents of family violence, they were in the past, or they were related to a previous substance abuse issue that's then now being addressed. It would be something that the team and the mental health professional would have to screen carefully to determine if it was suitable for the collaborative process, and maybe even put some particular safeguards in place. For example, having all the meetings by Zoom, having people therefore in separate rooms. Substance abuse issues cases, again, can be possible, but again, there might need to be safeguards. So it depends. If somebody has a substance abuse issue that they're not addressing and they're not taking responsibility for, then they probably need to be, you probably need them to be in court and be under the eye and the orders of a judge. If, however, the person is, perhaps they've done rehab, or they're blowing regularly into a breathalyzer and they are taking responsibility for that, then that again, with the team's assessment, that could be suitable for a collaborative process. Mental health conditions, again, it depends on the mental health condition. It depends how active the issue is and how it's being addressed. So there are some mental health issues. So for example, anxiety, depression, generally not a problem. In the collaborative case, actually probably better suited, certainly anxiety, better suited for the collaborative process because court is very stressful. But if you've got issues where someone perhaps has a personality disorder, then again, probably needing the eyes of a judge on them. So let's talk time and money. Cheapest is probably, yes, the uncontested divorce where you don't have any lawyers. Again, as I said, minimum 61 days. But again, just a caveat, be really careful if you've got property and or kids, just go through that checklist really carefully, think about all the eventualities and wonder what might be a problem in the future. And if you have any doubt about it, seek legal advice. Adversarial divorce, they can last years, they can last months, they can last years, and fees can be limitless, partly because you and your attorney are generally not really caring about the fees that might be racking up on the other side. So you don't really have much control over the money that's being spent throughout the divorce because you've only got control of one side, and often you don't even have control of that if the other side is constantly trying to have hearings and rack up your costs. As I said before, generally includes mediation. Now, mediation, I can give a bit more of a solid number on that. The minimum you're paying, say you're paying for the mediator, both sides are paying, and that's for a full day of mediation. And then you're each paying for an attorney at their hourly rate times 8. So at a minimum, you're generally looking at around $8,000 for that day of mediation. Now that's just the day, it's not the preparation that goes into that. Collaborative divorce, yes, it can be more initial money upfront because you're, instead of paying 2 retainers to 2 lawyers, you're paying 4 retainers because you're also paying the mental health professional and the financial neutral. But know that, as I said, the experts deal with their own area of expertise. We are all very mindful about everybody's money, and we don't have people on the clock that don't need to be. So for example, if we're dealing with parenting issues, then we don't invite the financial neutral all the time. Or if we do, we only invite them for part of the meeting we feel they need to be there for, and then they leave. We don't have meetings when people don't have sufficient information to make that a fruitful meeting. Everybody is very mindful of everybody's costs in the financial, in the collaborative process. And again, it can result in more lasting solutions because you have reached a negotiated settlement, which tends to be more durable because you've had buy-in to it. The average case, again, lasts 4 to 8 months. And again, going back to that durability, often the durability, the issue arises where you have quite young children and things change as they grow up. So in the traditional litigation model, you would probably quite likely be going back to court for a modification later on down the road. In the collaborative case with the mental health professional, if you choose, you can go back to that same mental health professional who was the one that was party to all those joint meetings and go to them and use them as a resource to try to brainstorm and problem solve any issues you have down the road. So it can, again, help keep you out of court further down the line as well. So can you swap between the processes? So say you start with one and then you decide you want another one. Yes, in theory you can, just a few caveats. So self-litigants, pro se people, as I've said, you can absolutely stop being a self-litigant and hire somebody and go into either traditional or collaborative, but just be really aware of the agreements you've made before then, especially if you've signed anything. Hopefully, if you've got an agreed final decree of divorce that's been entered, then that's too late. It's going to be hard for someone to help you. Mediation, as I've said, just be really cautious if it's outside of the litigation process and you haven't had legal advice. So again, of course, if you've done it, but it's failed and you haven't got a mediated settlement agreement out of it, of course, you can then absolutely feel free to move into one of the other processes. Traditional litigation cases can become collaborative cases. Say you start out in traditional litigation, maybe you didn't even know about collaborative. You start out with that, and then you and your spouse suddenly say, oh my gosh, what are we doing to ourselves? What are you doing to our children? There has to be a better way. Well, generally there is. It's collaborative. And so you can convert to collaborative case, again, before the entry of the final decree, but just know that obviously tensions perhaps have already been raised throughout that process. So it might be more difficult for the collaborative team to try to sort of settle emotions before moving forward. And yes, a collaborative case can become a traditional case if you fall out of the process. But first of all, you have to fire your lawyers. That is set in the statute. And you have to wait 30 days before a court hearing can be held. And that might sound like a bad thing to you, but it's actually a really good thing. It is a safety valve. It is partly what helps the collaborative process work. So again, collaborative, 95% success rate. But that is one of the reasons, because people are not constantly threatening, I'll see you in court. I'm going to take you to court. Wait till the judge, hears what you have to say, that kind of thing. So it is a really good thing. And yes, if you really like your lawyer, then you can explore other ways of resolving something before you come out of collaborative. As we say, you can do mediation through the collaborative process, and you can also do non-binding arbitration as well. So if this all sounds fabulous, but you're thinking, I have to get my spouse to agree. So here is a list of some of the things that might help your spouse agree to collaborative. So there's a lot of those things before, not going to read them out. But finally, if your spouse still isn't convinced, then feel free to schedule a short joint meeting with me or another collaborative attorney, where I would be happy to explain the process. Of course, I'm not going to give legal advice in that meeting, because that would be an ethical conflict for me. And don't worry, if you're the one that called me and you want to move ahead with me, then I give first dibs to the person that called me first. So that wouldn't stop me from acting for you in a collaborative case going forward. Here are some resources. So my website, if you go to the resources page, has more resources. Collaborative Divorce Texas, which is also on there. So you can go to kateprattlaw.com and resources, and Collaborative Divorce Texas will be on there. Collaborative Divorce Texas is the umbrella organization that deals with, that houses all the collaborative professionals, essentially, virtually. So you can find lists of collaborative attorneys, financial neutrals, and mental health professionals on there, and a wealth of resources on there. And they're the ones that set out the procedures that we follow when we do the collaborative process, the details of them. And then texaslawhelp.org, that is really designed for people who are self-litigants, pro se, but it's actually incredibly helpful, I think, for anybody that's anticipating going through a family law matter. So again, that is also referenced on my website. If you have any questions and you need help, then feel free to go to my website, kateprattlaw.com. You can email me, very obvious, kate@kateprattlaw.com. You can call the office. It may well go to voicemail, but I will return your call if you leave a message. You're also free to schedule an initial consultation. I offer 3 free 30-minute initial consultations, and I would be happy to talk to you. And that's it. Thank you for your time. I'm going to stop sharing. I really appreciate your time, and I am sorry that you are feeling that you're having to learn about divorce processes, but I'm glad that you are possibly thinking about maybe collaborative now, because as I said, I do believe it's a better process. I am happy to talk about all divorce processes to you if you like. And that's it. You have my details. So thank you for your time. I wish you well.